Welcome to Probate Weekly. I'm Bill Gross, your host. We do this every week and talk to leaders in the business, whether it be attorneys, professionals, vendors, real estate agents. I'm excited to have today somebody who I've known before I got into probate business. He was a friend. In fact, before he even became a friend, I knew his wife, and we've watched them grow up together. So I would say personal friends as well as since he's been in the practice of law. We've touched base from time to time about the business. And he's located in Nevada, so it gives a little different perspective on the business. Robert Tzall, Esquire. Robert, thank you so much for joining us today.
Thanks so much for having me, Bill. I really appreciate it.
It's always fun. And this is my business, talking to friends about probate, estate planning, helping families. And just to clarify the legality part of, or the title properly, Stuno and Associates is the firm that you're with, and you're partner with the firm. But your practice is, I think, based kind of broad-based, what I call probate, meaning you do probate as well as avoiding probate or estate planning. You do guardianships and conservatorships and such as well.
Everything that has to deal with those, I'll put it this way, those, as we get older, as we start thinking about our legacy, everything that deals with that, whether it be something really happy where we're creating a foundation, or something on the other end of the spectrum where it comes time for someone to pursue a guardianship or something like that.
So let's start off with not just the unhappy part, somebody passing, but the part where they messed up and didn't have a plan. We call that probate. One of the misconceptions in California is if you have a will, you avoid probate. The truth is, in California, you take your will to probate, and as part of the process, even without it, the process is almost identical, other than arguing over the will. In Nevada, does a will avoid probate, or does a will get probated in Nevada?
Same thing. It gets probated. So if someone's looking to avoid probate, they need to have more of a robust estate plan. And really, an estate plan is an act of love. Probate, we were talking about for a few minutes before we started recording. It's tedious. It's a lot of paperwork. Some people always want to ask, what's the fastest we can do it? What's the deadline? And that's always hard because there's so many hands in that bucket. So if you really, really, truly love the people that you want to leave stuff to, there are different vehicles than a will. And also because they don't have to be probated, there's also less expense to the estate.
So let's start off with the before picture, the probate, if you don't plan what life looks like. So when I run a list in California, the average probate closing is over 2 years, even though theoretically it can be done in 9 months, 10 months. Theoretically, if everything was done as quick as possible, but the average is longer than that. Based on actual data, what's the average really look like in Nevada? Because there's what it should be, but we have human beings doing the paperwork, and we have courts and systems and vacations. What's an average time period from the beginning of the opening of a probate until the final disbursement of the funds to the heirs?
In my experience, it's at least 18 months. I mean, unless it's a very small estate, or there's something, or there's something unique, like you were just saying, there's paperwork. While there's deadlines, I'm sure in California, it's something like 60 days. You have to let the creditors know, 90 days to do a publishing and whatnot. But like you said, we're at the mercy of a lot of different people. Right. So in my experience, 18 months. The soonest that I've got one for a large estate. I don't know if California has like a small estate and larger estate, but is 9 months, and that was busting. That was busting everybody to get that done.
So while we're there, what's the distinction in Nevada? Now, in California, we have a new law just came out for decedents April 1st, 2025 or later only, where primary residents, and there's some other conditions, and I have a whole podcast episode coming up on it, up to $750,000. There's a streamlined limited process. Still going to take a few months, but it's limited. So so we have a under 168K, which is more for a bank account. We have 750 for that particular case scenario of single family, and then we have everything else gets piled into probate. What are the distinctions, if any, in Nevada?
So we have 3 levels. We have summary probate for if it's below $100,000. If it's between $100,000 and $300,000, it's still a full probate, but our statute provides for shorter deadlines. And then once anything over $300,000, whatever type of asset the estate has, then it has to do a full probate.
Got it. So one of the things people also don't understand about probate is while everything might look smooth and easy when you start, my experience is the longer it goes, if you have multiple errors, it's kind of like having food in your refrigerator. Something goes bad at some point, and it just takes one. And I think people are shocked to find out that one difficult heir, one difficult sibling, one difficult cousin can just throw sand in the ranch here in California, it can go from being a year or two process to being forever and very expensive. Is that similar in Nevada? What's that process look like when you have one person maybe objecting, and they may not be reasonable, they may have no documentable grounds, but they just want to slow things down or stop things. What's that look like in Nevada?
If somebody filed something into a probate saying, even if it was totally baseless, I have a claim, whether it be a creditor claim or an heir, it's pushing things back at least 3 to 4 months. Whatever that deadline was, we can basically say the next 3 or 4 months are cooked on resolving this issue between the court and between trying to deal with the people in negotiation. You're talking 3 or 4 months pushing things back minimum.
And then you've got to have the attorney has to respond, meaning theoretically, some heir files a objection to the petition, and maybe their own petition. At least that's what it looks like in California. And then now you've got to have your attorney file an objection to their petition and a defense of your petition, typically not included in the standard attorney's fees. So now you're starting to pay more money. There's filing fees and things like that. So that's where I find probate costs can very quickly double or triple. Of course, it goes to a hearing and a trial. Who knows what the costs are going to be?
Exactly. It's like any litigation. Say people want to say how much litigation is. I don't know. It depends how far we have to go down that rabbit hole. Additionally, also what I find with when people, my words, come out of the woodwork, it's sometimes not just the money. It's some other issue that's, you're a real estate professional. I'm an attorney. We have our skill sets, but these problems existed long before probate, and those issues slip in as well. I had a case in last year where my client wasn't even really interested in the money. She filed the objection because she was estranged from her mother, and the executor refused to give her any portion of her mother's remains, and that became the big fight.
Wow, portion of the remains.
Right. So I know people have different thoughts about this, but she was, when we were talking, she was like, "I'll even take a half of it." How do you measure half of cremated remains? I don't know. Interestingly enough, I'm not sure how it is in California, but here in Nevada, courts do not want to hear about fights regarding remains. They will not disturb them. Basically, the person took responsibility for them at death, barring either cooperation between the parties or some other situation. They keep them, even if they're not necessarily the closest heir.
And I think if anybody's listening to this, whether you're individual who has property, has a family, and is horrified by the prospects, or if you're like I am, a real estate professional or other professional, we want our customers to avoid this. And so part of the reason we're going in a little deep on the probate side is if the cows get out of the barn, what life looks like, but we want to build a good barn that doesn't let the cows out. We call that estate planning. So let's talk about the estate planning. You mentioned that as an act of love. So one of the challenges is just, not for you, but for me, I'm not in the business of estate planning, but I advocate all the time to my customers and to prospects and to team members, is getting people to take action because it's not urgent, obviously. So what do you see the difference between people who actually finally get to doing something on an estate plan before need, or is it now mom is getting really ill and that's what they're racing for? Do you see people who plan ahead, or is it almost exclusively people who are racing some sort of impending disaster in their mind?
So in my practice, I see it mostly people planning ahead. Whether planning ahead might be 50 years ahead, might be 10 years ahead, but rarely do we get a call from, do I get a call saying, hey, this passing is imminent. We must do this now. Typically because there's so many, as a practical issue, there's so many other things going on, with the person's health and welfare that they don't even get a chance to discuss them, even if they're important issues. So, what it comes down to really is it's a difficult time when people pass, and you want to create as little friction as possible. And the more friction you create, the worse your experience is going to be. Another area of my practice, just to speak real quickly, is in surrogacy and assisted reproduction. And my saying there in that field is, you want to have, when someone asks how your journey was, you want to say it was great. You don't want to say it was great, but. And you don't want, at the end of the day, we're talking about human beings. We're talking about lives. We're talking about emotions. We're talking about souls. And you don't want the conversation to be with somebody when they find out a relative passed, and the conversation goes and not talk about how that relative was important to you, not how they made an impact, not how they made an impact on the community or the world, but talk about the time, trouble, and treasure that's involved in the probate and sorting everything out.
So you also handle trust litigation, which I think most commonly is an estate plan, but somehow, again, another misconception is you avoid litigation if you have an estate plan. Well, you might minimize the chances, or you might strengthen your chances of winning. But the court, at least in California, and I believe it's true in Nevada too, is filled with litigation related to estate plans being litigated one way or the other. So, what are the most common areas that you see litigation involving estate plans? Somebody took the time to fill out the estate plan. What happened that they weren't able to avoid litigation?
The two are two. The following are the two biggest issues. One, when property is not properly transferred into the trust.
Well, let's stop right there for a second. I'll come back to the other one, because that one, obviously, I'm a real estate agent. That's what we deal with. So, not properly transferred trust. Now, in California, we have kind of like a get out jail free card, but it's not free, called the Hague petition, where the court will consider transferring a property back in the trust. That was clearly the intention. And so everybody in California should be aware of that. We would know that you can advise customers to ask about that. The problem is it's as expensive as probate and may even take longer than a probate to do. So on one hand, it's a solution. On the other hand, it's very expensive, very slow. Now in Nevada, do you have such a reversal process? Or if you forget to transfer it, are you just out of luck? Like in most states, I know you're just pretty much out of luck.
You're out of luck. You're out of luck. Absent something where someone could produce a writing, which is which would take the form of an amendment or something like that. But really, you're out of luck. And most people, they think, you've seen a lot of trust documents. They think in that Schedule A or Exhibit 1, if you listed it there, that's enough. Rarely it is.
There's nothing like being with a customer who pulls out the trust book. They're very proud of the book they get. And they pull out the list that has the addendum A and has the property on there. And they pull out, the next page is almost always the deed into the trust that the attorney gave to them to get notarized and recorded, and they never did. And it's like, well, now we have a problem. Now, again, California, there's a potential solution. It's not guaranteed, and it is expensive. And in Nevada, you probably don't have a solution at that point. And so everybody listening here, I think it's really important to work with the attorney to, I think, help follow through and get the customer what they wanted, which is get the property in the trust, or it's called funding the trust. So some attorneys are a little standoffish with real estate agents because they see us as just always asking for business. I would take the position that I want to follow up with the customer, at least make sure the property got transferred. I can check public records. I don't need to bother the attorney to find out. The opposite, I can find out it's recorded and send a copy to my customer and copy the attorney so you know that's done. So when you do estate plans, do you follow up with the customers that get these things done, or do realtors who are free business follow up? What's the process look like to make sure that they bought the safe, that they put the things in the safe, close the door, and spin the lock?
So one, we have extensive, depending on the client, some clients want to come in and execute everything here on one day, and we're happy to provide that service. A lot of folks don't want to come in, and we provide extensive directions, and then we follow up 6 to 8 weeks later. We do have an estate management plan that some of our clients use. There's an annual fee, and that's a little more hands-on if they have questions, and that allows us to be a little, check in a little more and be a little bit more proactive.
I like that personally. I always look at, my father was an attorney, and he didn't do estates and wills, but his partner did. And they were old, obviously older than me, and I'm old. And they had a vault in their law office where in those days, you put the original will, the attorney held it. And that was a common practice until at some point it became common practice not to do that. And I'm not sure exactly why. And then I think now it seems like half are in and half are out, where half will hold it and charge a fee, and the others say, no, we don't have anything to do with it. We'll put it online and give you a copy of it, but we don't really have the original or verify that we have the original. How do you handle or advise the handling of the original documents as far as trusts?
So I actually think the originals should be with the client. Attorneys are, we're awesome, but we're just human beings. We die, we go out of business, we go on crazy trips. And if you leave, well, we'll get to the original part in a second, but by leaving with the attorney, there does come some risk. I think it's perhaps advisable for the attorney to have a copy, but I don't see this necessarily original reason for the original. I think the reason attorneys were doing it in the past was estate planning was a lot less, there was a lot less trust and a lot more probate. So the attorney that did that drafted the will ultimately, regularly did the probate. So I think that's not as so much the case anymore. Additionally, if they have the original and we have a copy, say, well, why do you need a copy? One, so we can look at it and say, hey, you signed it, you executed it correctly or not. But also, if something happens I'm sure California has something similar. If the original is lost, a reproduction can be entered as long as there's enough evidence that it was actually executed by the decedent.
Otherwise, you have nothing. And I've had
Yeah.
numerous cases where customers come to me with a property that's in a trust, and the kids can't find the trust, or the person, the trustee can't find a copy of their trust, and so and the attorney's no longer around, or they use a service and they can't access it. Sometimes they do, and there's different things. But too often they can't find a copy of the trust. Now what have you accomplished, right? That's a whole nother challenge that gets to being illegal. So sorry, I just want
to go back to your point. That goes to my second point about like what do we see litigation coming up in? It's not telling people your wishes. It's only legally binding if it's on paper, but when people are surprised to find out what that paper says, they sometimes go to incredible lengths. And so one of the things, like you were mentioning, originals, even, you might not want to provide the original to the successor trustee, but at least provide a copy to them, let them know they're going to be. That's on a happy end. On a less happy end, I have many estate planning cases where it's a blended family, and they want, there's 6-8 children, and for whatever reason, some of those children didn't make the cut. Beneficiary was.
That is never pleasant. I'm not singing your chair on those, but on the real estate side of that, man, they just want to kill each other. Some of them just want to kill. The fact that that kid got $10, like they would die if they could get that money out of the person's hand. It's just amazing. And I'm blessed not to have come from that circumstance, and so I can't really imagine. I'm sure there's some legitimate pain involved in all that. I had one where the husband had an illegitimate child and didn't tell his wife or daughter until later in life. Well, you can imagine their feelings about this daughter. And he had a trust he didn't execute. And so in essence, in California, it's as though he died intestate.
Intestate.
And so I guess by law, she was the daughter of the first wife who died. And so the second wife was alive. And I believe the way it worked out was this daughter who was illegitimate or whatever, out of wedlock, got like half of the inheritance. And of course the daughter, when she found out about her half sister, you can imagine she'd feel cheated and betrayed, whatever all those emotions are. But imagine that person getting half of maybe $1 million estate. I mean, it's just brutal, the legal process there. So, and again, if that's what you want, I think you're entitled to do that and put it in writing. And it might be he didn't have the courage to tell his wife that was his intention. Who you don't know. You just don't know how it all works out. But I think your point is right to communicate as best you can. Otherwise, you're really leaving a mess for somebody else to clean up. I interviewed an attorney last week, and I've been in this business for a while. I feel like I'm an expert in these subjects. I was shocked to learn something that I didn't know, which was, maybe this is a California law, that when a property is in a trust, the trustee, when the decedent passes, and it goes from being revocable to irrevocable, that the trustee is obligated to notify all the beneficiaries of the trust, as well as all the heirs at law, meaning if the decedent had written out of the distribution, say a son, that the trustee would be obligated to let that son know within 60 days that they had gone revocable, they had become irrevocable, and that all of those heirs and heirs at law and beneficiaries have the right to request a copy of the trust, and I think they have to get within 120 days, so they can actually see the trust and see the actual terms. Because as a real estate agent, I often get the phone call, hey, I think they're leaving me out, they're not telling me anything, I don't have any paperwork, and then I'll say, well, you should talk to an attorney. Well, that's a tough phone call to make because, what's it going to cost? And people don't necessarily know up front. So a couple questions, if I can. First, if you can clarify in Nevada in general, and I understand you're not giving legal advice, but just the general principle, when there's a trust and the decedent passes, and therefore that trust that was revocable most commonly becomes irrevocable, is the same rules? Is the trustee obligated to give notice to heirs and beneficiaries of the trust?
No, only beneficiaries. Only beneficiaries.
So for example, if there was a son who would be an heir at law, but he was written out of the trustee would not be obligated to notify him of the
Correct.
trust, and he would not be obligated to know a copy of it.
Correct. He would have to start litigation in order to get the copy of that trust in discovery. And I'm sure, as you're aware of, anytime I know when I draft, I have no contest clauses. So if they were to get anything, if they're to get anything and they didn't know, or they don't, I'll put it this way, they're supposed to get something and then they contest it because they thought they were going to get more. There's always the chance of them losing everything.
So then does the heir in that case just wait until everything's distributed? By then it's too late to sue. Or if they sue right away, they don't know they're being written out. So how does that even work out when the heir suspects he's being written out but doesn't want to lose out? I
So a couple
guess.
of things. One, you can. It depends how close you are. Meaning, if it's something that I'll put it this way: if an attorney called me and my client gave me permission, I wouldn't have a problem sharing the trust document with a non-party, even though it's a private document. Obviously, like I said, with the client's permission. But beyond that, if you're trying to get answers, and within, I'd say, 90 days of somebody's death, you're not liking the answers that you're getting, litigation is really your only move here in Nevada, because
And
otherwise, like you said, how are you going to find out? You're not legally entitled to notice.
so on what basis then you file litigation? Because you don't have any basis to know you're being written out. That's
And
a
that's the problem, because so you have to allege two things. One, either that there is a trust, and that you're purposely being kept out of it, either by the successor beneficiary or by the attorney, or you have to say that on your knowledge and information that there's something wrong with the trust. It was terminated. It wasn't executed properly. For example, little different of the scenario you're talking about is people can have two copies. I'm in it, and then several years later, I'm not in it. Well, I'm not a California attorney. My firm has offices in California, and the case that went on was we firm represented a client where the everything was going to go 50-50 to the kids. He had a stroke. The kids didn't want to take care of him. His maid of 20 years took care of him. He gave her everything. So
classic.
in that case, classic. In that case, those folks had reason to believe, they did, their father didn't tell them during their lifetime. Certainly, we didn't have a duty while we were drafting to tell them, but that fell on the client on our attorneys in California. That fell on their shoulders to tell those kids that they were out.
Yeah.
But going back to Nevada, really, you have to have some sort of, and I talk to folks at least once a week like this. You have to have some sort of good faith reason to believe to start fighting. Otherwise, it's probably going to result in you spending a lot of money and not getting any money.
And so the reason why you might be willing to disclose the trust is because both why make them litigate if you're going to show them they're written out, but if you have the no contest clause, you're putting that up for them to see as well. And so you kind of are saying to them up front, it's not worth your time to litigate because you're not going to get anything. And if you were going to get anything, you would lose it as a result as well.
And they're going to, everyone, this is not something that people can do themselves. They're going to have to use an attorney
Right.
properly. If
Right.
I give them the trust and I'm confident that everything's fine, they're going to take that to an attorney to try to hire, and that attorney is going to look at it and say, happy to help you, but no promises.
Yeah. Yeah. Wow. And so that's why I think these things, it's so critical. The one common denominator in avoiding problems in everything in business, I think, is preparation and communication, preparing the documents and then communicating it. And I think that, though it's easy to say for a decedent to tell, kids, you're written out, you're half written out, I'm giving my caregiver. Those are tough conversations. People don't have those conversations when they're alive, let alone from their deathbed. But obviously, not having those conversations, I think, make it difficult as well. So, and I think also to your point about the story with the kids and the caregiver, it is interesting to me how entitled heirs feel when they're not around their family, family member for years, right? I mean, easy for me to say. It's tough to be around a sick, but we've done that. Me and my wife have been through 4 unfortunate, long, drawn out processes. Not because we're inherited some incredible sum of money, as it turns out, but because that's what we did for our family members. And I think sometimes, children they take out their guilt, what they feel emotionally, on through litigation. And that's why I think that even if you do everything properly, having the documents done right and the communication is so important because you can't avoid being sued. If somebody feels cheated, and they have the money, they're gonna hire an attorney, they're gonna come after you. There's no way around that, I don't think.
And you know, and not only in estate planning, but in some of the other areas of law, people will speak to me and they say, we don't have a current controversy, but I want to make sure there's not a controversy. What can I do?
Mm,
Is there some
mm,
magic pill? Is there something I can do?
mm,
There's no magic pill. It's really just, it's like you said, it's preparation. It's
yeah.
doing everything right because I can't, like you said, people can't stop. No one can stop anyone from starting a lawsuit. The best we can do is stop it as fast as we can. And I think, a lot of people, it's, a lot, on the other side, when I'm doing business litigation, businesses will, they'll want to say, how do we protect ourselves? And I'll say, well, it's like you're talking about documentation, insurance, business. Like, so if someone sues you, you can say, hey, we weren't negligent, we didn't breach, we didn't, et cetera, something like that. And I think that it's, especially with something so personal like estate planning. I mean, I don't know, some people don't want to think about the hereafter. And it's simple as that. Some people don't think they have anything to give. Some people, they have a lot to give, but they're estranged from everybody. And, that's an emotional part as well. They're not, at the end of the day, they're doing it not because they're lazy, they're doing it because they're lonely. And there's no one sitting there and helping, suggesting that they do this.
Um, I don't think this is a newsflash. You and I are both Jewish. We're both religious Jews. That's how we met really through our religious community here in Los Angeles. And in the process of estate planning, one has the opportunity to document and instruct how they want things done, whether it be who's raising the kids or how they want their, process to be done, physically, burial versus, cremation and such. And in our world of religious Jews, we have some fairly strict or specific, I should say, instructions. I know of an organization called Emitai that has put together kind of like an addendum that would go to an estate plan. Do you consult with religious Jewish families on estate planning? Is that something that you've developed on your own? Is it another
Yes.
organization you use, or is Emitai one that you've worked with?
So I work with the RCA.
Okay.
And so they started producing templates that go very well with contemporarily drafted estate plans. I think it's important because a lot of people, I'll put this way, whatever the faith is, I think it's really important. And going back to wills for a second, we've kind of been trashing wills because of the probate part, but wills are really important because while you can put those wishes in a trust, the real place to put those wishes where they're enforceable is a will.
Mm,
So if you have those wishes about disposition of your remains, they should absolutely be in your will. They should also be in your advanced healthcare directive.
mm,
A lot of people, I'll talk about that in a second, but what I think that any attorney, whether they're Jewish or not, who's working with religious folks, they owe it to their client to at least be competent enough to talk about these issues, so they can suggest alternatives, so they can be compliant in whatever religious tradition that is.
right. Yeah, and I know in our forms now, he mentioned the RCA, Rabbinical Council of America, is is probably the leading organization on various related Jewish law issues. But I think that there's a number of issues. One is appointing, well, if it's not covered in this list of instructions, who's my spiritual counselor? In my case, being Jewish, who's my rabbi, right? If you're Catholic, who's your priest? And that way, if there's something that's a question, then they would be able to make the decisions that's consistent with your religious beliefs, whatever they are, whoever that is. To not do that advocates that role. And I know we went through that with one of my family members where we kind of knew what she wanted, but she didn't put it in writing. And it was something that we're not, I didn't agree with. But at the same time, those were her wishes. And so I went to my rabbi. He said, well, if that's her wish, that's her wish. It's not my place to intercede. And that's difficult. Those are things that you want to have in writing and try to make those decisions as if that's important to you. Now, it may not be important to you. And I think other personal things like caring for pets, there's pet trusts and there's, charities and identifying those charities with your distribution. So these are all things that rather than leave it up to somebody to decide. Now, do you get involved in those kind of decisions as far as helping people identify charities, or you just ask them in the process of the estate plan and they identify them, or what's that look like?
So some people have an idea, but really, and this is kind of the fun part of estate planning. we're talking about all the negatives that happened, but just like the documents themselves are an act of love, these gifts are an act of love, or these bequests are an act of love. So you kind of, it's really nice when you can open up somebody's eyes and say, hey, whether it be $1 or $100,000, you can give this to an organization, or you can give this to a cause that's connected to you. So a piece of you can be built into that organization. I think this is going to become a much bigger issue as we see demographically fewer people getting married, fewer people in relationships. Making a living is always hard, but most people pass away with something, whether it be big or small. And if you don't have a spouse or a partner, and you don't have children, that doesn't mean that money is just useless. I mean, that still can be a great act. That still can be a huge gift to something or someone or something.
I know it's really important, and have a family member passed away who didn't have any other children, and we made a decision. I was a trustee, it turns out, by consulting with the other heirs, and said, look, they didn't make any designations, but I think we all want to contribute something. Why don't we just take it off the top, and that way it's in her name. And so we actually were able to contribute something that endowed her. It was not much money, but it was enough that it becomes a recurring gift to an organization that was important to her. And I think those are things that we have a chance to create a legacy. That's a good way to put it. I'm sorry.
Going back to one thing you were talking about with wishes, just to give you an idea, like and for religious folks who are Jewish, something specifically I put into their advanced healthcare directive is no one can take any action that's incongruous with Orthodox Jewish tradition, and if a person attempts to do that, they are the successor attorney, in fact, can take action against them to replace them.
And now that's obviously if they're Orthodox, then you have people who aren't. And I think, again, whatever you are, you can put it, you can codify that. And if you don't, you're kind of leaving it open for arguments and disagreements and things like that. Also, who's going to raise kids? One of the things that, we talked about with my daughter who's married and a lovely guy. In some ways, he's like my son. And we have now 2 grandkids. Well, God forbid something happened to 2 of them, who's going to raise them? And my daughter's blessed to have 2 sets of grandparents around. And as well as my son-in-law has 2 siblings. Well, they made a decision that I said, I don't really care if it's us or somebody else. I don't care who it is amongst that group, but let's designate somebody so there's no argument, because somebody has to make those decisions. And if they're empowered with decisions, then there's no more room for argument. If they're not empowered, then you can do nothing but argue. They should go to this school, they should go to that school, they shouldn't go to school, it's too expensive, right? Those are things that somebody has to make those tough decisions. And if you designate them, they can make those tough decisions if you don't designate them. So I would imagine one of the real challenges is getting the right trustee in place, right? People have a sense of who that person should be, but often I think their idea who that person is isn't consistent with who probably would be the best trustee. What do you advise clients? And just an example, I think in my case, I can think of maybe my brother-in-law, who's a very successful businessman. Well, he'd make great decisions, but he's so busy, he'd be the wrong person to handle the details. He would maybe need to hire a professional fiduciary to do the actual work, and then he can make those decisions like for them or instruct them or whatever was appropriate. But how do you consult with clients as far as picking the right trustee? Because I know that makes or breaks the whole deal.
Absolutely, 100%. I was just talking this with a client last week. She has 2 children. Her daughter's turning 18, and we've had extensive conversations. And one of the children is special. The other child has special needs, and he's much younger. That's a lot of responsibility for someone that literally just turned 18 30 days ago. So you're 100% right. A couple of things. First, we live in a world, you're married, I'm married, but we live in a world where we know many divorced people. Even if you have primary or sole physical legal custody, if you're the one who passes away, that child is going to the legal parent. There is very little, I'm not sure about California, but at least in Nevada, that they're still a legal parent, they still have parental rights, and they're going to that other parent, even if that parent is estranged. Now, if that parent decides not to do something, that's one thing. But a lot of people say, I hate my ex-husband, I hate my ex-wife. I would never want my kids to be raised by them. It's kind of hard to get out of. That's one. But 2, you mentioned about people. 1, it's not only there's the skills similar to be an executor or similar to those of a trustee, Even on that note, if you name somebody to be the guardian of your children, I always recommend, strongly recommend, that the person who's the guardian is not the person who's the trustee of the money left in the trust to benefit them, because people are awesome, and we all make mistakes, and it's very easy for someone to love and care, but still take a few bucks here, take a few bucks there because their own pot is light, and then time for college, and they realize there's $100,000 missing. And it's not an indictment on either party. It just makes it a lot cleaner. And typically, the person that you want to raise your child is not necessarily the person who is the Warren Buffett in the family. They're two different skill sets. The other thing is I find that people, they'll name one person also to do anything attorney in fact related or advanced healthcare directive related. And again, a lot of power for one person to have. Again, different skill set. People ask me again on the advanced healthcare side. They'll say, "I want all my children to make decisions about my life." You understand exactly.
Yeah.
So,
no, having been down that road, no, you do not.
So what I do suggest to people, though, if you have multiple people, at least on the statutory form we've adopted here in Nevada, you can tick off that. They're allowed to take anybody's opinion, but they don't have to necessarily follow it. And if you have an extended family or you have people that you want to give informed, opinions to the attorney in fact, there is a HIPAA release where at least the parties they can't make decisions, but they can get information so they can talk intelligently with the person making the decisions, and perhaps that'll be beneficial.
I've been in court where I've seen people arguing where somebody, the first example you gave of the guardian also being the administrator of the funds, and the guardian took a child to I think it was a Carl's Jr. or something, and got burger, fries, and Coke for both of them, and one's arguing that they're benefiting personally from the finance because they're paying for fast food while they take their kid out to lunch. And it's like, really, at some point, but you set yourself up for that to some degree, and those are. I'm not saying one's right or wrong. I'm saying that these are difficult jobs. You're going to get criticized. You're going to get, if there's bad blood, there's going to be arguments. It's going to go to court. It's going to be embarrassing. You want to try to limit that as much as you can by thinking through and working with a professional to avoid these things. So, as we kind of move to the business side now. So talk a little bit, obviously I'm a real estate agent and I work with real estate agents around the country, including in Nevada. There are companies that sell real estate agents a package where they, get cases and they tell them to cold call petitioners, cold call attorneys. I kind of take the opposite approach. I really want to learn the business and try to develop relationships. Talk a little bit, if you had a nephew who was starting out the business in real estate and wanted to participate in probate real estate or litigation related real estate or in this area, what would you advise them to build their business? What would you say would be good steps for them to be productive and to learn the business and be good at it?
So I think you kind of said it a few minutes ago. Our businesses are this way. People know us, and people know our work and like our work, and even if they haven't worked with us, they like our approach to things. And I think the most important thing is to really go out and meet as many people as possible. I mean, we're doing this virtually through this podcast, but I think that most people they're waiting for people to call them, and they're not looking to talk to people. And it's something like probate. It's to talk business law or intellectual property with somebody. That's really that. Most people doesn't affect their lives one bit. But I would say be as broad-based as you can, especially with financial people, especially with real estate people, because I have people all the time. They buy their third house, and that's what makes them their third investment property. That's what makes them think about doing an estate plan. So I think really it's like everything. Surrounding yourselves with groups of people from different professions, and being able to rely on them. I know what I do is I get out. I talk to bankers. Bankers are a huge source. I talk to financial advisors. I think that you have to. Maybe if I was a younger man, I would be able to do TikToks about this. But I think there's a lot of misinformation about estate planning. At least once a week, I get somebody who calls me who makes $31,000 a year who wants to start an asset protection trust.
Yes.
And
Yeah. Yeah.
And that's really something that someone who has $10 million in assets, they don't have to touch or intergenerational. Well, that's not for most of us. And I think that a large part, people I don't want to say complain, but people comment sometimes on the cost of estate planning, and I think that's because a big part of it is the education.
Yeah.
And I think that's what if someone's looking out there, provide the education for free.
Yeah. Yeah, and oftentimes realtors say, well, I don't know how to do all that. I say, well, you just listen to a conversation today. It's been so far 40 minutes long. If you learn one thing along the way, 1 or 2 minutes of information, take that, maybe research a little bit more and just talk about that. And I would push back a little bit on your argument about not doing TikToks. Now, I don't like TikTok as a format for other reasons. I think it's not the educate. That's why I do YouTube, because TikTok is more entertainment. I think YouTube is more about education. But I would say anybody in any business has the opportunity to educate their customers or prospective customers. And anybody, we all have phones. We all just point there, shoot video, upload it to a YouTube account. And so if you're busy enough and your hourly rate, you may not want to do it. But for the rest of you on the watching this, I would encourage almost anybody, get a YouTube channel and start talking about what you can do to help other people, and there'll be people come to you for that help. So that said, Robert, I really appreciate your time today. If you're interested in learning more about Nevada estate planning, Nevada probate work, or you have a particular case with children, guardians, and such, Astuno is the firm. Astuno.com is the website. Robert Tzall is a partner there, and his information I have down below. Phone number 702-268-9297. And R for Robert Tzall, Tzall, at Astuno.com is the email address. Of course, if you don't write this down or don't look at the notes, reach out to me, but more glad to make the introduction. As I said, Rob's been a personal friend. I don't know how long it must have been before we moved to Arizona. I mean, to Nevada, it must be
18 years.
It's been that long. Wow.
Yeah.
Wow. So we've known him for.
You look younger,
years.
by the way.
Thanks. And it's a personal friend, so I feel very comfortable making that introduction. And Rob, thank you so much for your time today and educating people. I really appreciate you so much.
My pleasure, Bill. Thanks so much.
And for the rest of you, this is Probate Weekly. We get together every week and talk about how to serve our customers in probate real estate with an attorney or a real estate agent or vendor serving the market. We can continue the conversation at Probate Weekly's Facebook group, which is Probate Weekly. If you want to get reminders, you can go to probateweekly.com. You can sign up if you want to put your email in. You don't have to. You can put your phone number in for text messaging, as well as scroll down for the audio formats and or past episodes on YouTube. I'm Bill Gross. We have a new episode every I don't know what did we do anymore. I think it's Thursday morning, but feel free to sign up and get those reminders. If I can help, reach out at Bill Gross Probate. And as always, make today your best day ever. Thanks.